Hello again, this is Professor James Smith talking to you about the Federal Rules of Evidence. Now, in our last segment, we talked about character evidence, and I gave you the general rule. I'd like to talk a little more in particular now about character evidence, and I'm specifically now talking about character evidence in criminal cases. Character evidence can be introduced as circumstantial evidence of a particular defense. And what I mean by that is, let's say, for example, if the defendant is charged with robbery. Now, the defendant could decide to invoke what's known as the mercy rule and introduce evidence of a pertinent character trait which could rebut the contention that he committed the offense. The defendant may not choose to produce what we call direct evidence with regard to the robbery, for example, an alibi or an eyewitness who would say that he didn't commit the offense, but rather what the defendant could do is introduce character evidence as circumstantial proof that he didn't commit the offense. In other words, the defendant could present character witnesses who could come in and testify with regard to the defendant's pertinent character trait that would rebut the contention that he committed this violent offense. So let me not speak in legalese. The defendant could introduce character witnesses who would come in and say that he has a character for being peaceful, and this could be used by the jury as circumstantial evidence and circumstantial proof that he could not have committed the charged offense. This is the exception to the general prohibition on the use of character evidence. If the defendant does that, if he opens the door to the introduction of character, then the prosecution is entitled to rebut it. Remember, in criminal cases, as a general rule, the prosecution cannot introduce character evidence against the accused. They cannot argue, in essence, that the defendant has a bad character, is a bad person, and thus acted in accordance with that bad character on this particular occasion. However, if the defendant opens the door by introducing evidence of his good character or a pertinent character trait, then it's open season, and the prosecution can, subject of course always to the limitations under Federal Rule of Evidence 403, introduce evidence to rebut those good character traits offered by the defendant. Now, how could the prosecution do it? Let's go back to our robbery example. If the defendant introduces witnesses who are going to come in and talk about his character for peacefulness, then the prosecution would be entitled to introduce witnesses and other evidence to show that the defendant has a violent character or a violent nature. Now, one of the ways in which the prosecution normally, however, challenges any good character evidence offered by the defendant is through the cross-examination of those character witnesses. Now let's turn our attention to Federal Rule of Evidence 405. We now know generally in criminal cases that there is a general bar against the introduction of character evidence, but that a defendant can offer as circumstantial proof of innocence evidence of his good character or pertinent character trait. If the defendant does that, the prosecution is entitled to rebut it, and they can rebut it by cross-examining those witnesses. Now, how can character be introduced? And that's where we get to Rule 405. If you take a look at Federal Rule of Evidence 405, it tells you that there are two methods primarily by which character evidence can be introduced. And those two methods are reputation and opinion. In other words, if you're going to introduce character evidence, generally the only way that you can do it is by calling witnesses to the stand, and those witnesses will testify that the defendant has a reputation for having a certain character trait, or the witnesses can say that in their opinion, the defendant has that particular character trait. So, let me give you an example of what I'm referring to. Let's go back to our robbery example, where Jack is charged with robbery. He's not going to present any direct evidence on the robbery, but rather he wants to present character evidence as circumstantial proof of his innocence. Jack decides to call someone who's known him for 15 years, a next-door neighbor, Bob. Bob takes the stand, and Bob, on direct examination, tells the jury that he's known Jack for quite some time, that he's familiar with him. The defense counsel then is going to offer character evidence. The defense counsel would ask Bob if he has an opinion as to whether or not Jack is a peaceful person. Jack would say, yes, in my opinion, he's peaceful. This is opinion character evidence, and you have to show a sufficient foundation. You have to show that the person offering it knows the individual and has a sufficient basis for being able to offer this opinion evidence. On the other hand, you could call witnesses who would offer what we call reputation testimony. Our reputation testimony refers to the way in which this individual is known in the particular community. And when we talk about community, it could be a community of any size. It could be a neighborhood. It could be a dorm room. It could be a town. It could be a state. It could be a nation. It could be the international community. In other words, if the individual about whom the character trait is being offered has a reputation for that character trait in that particular community, well, then that type of evidence is considered to be relevant under the federal rules that can be offered. So under 405, we have the ability to present character evidence on behalf of the person, and we can do it either through reputation or opinion. Now let's talk about the very tricky area, though, and that is with regard to specific instances of conduct. Now, one would ordinarily think that if someone gets on the stand and says, well, this person has a reputation for being peaceful, or in my opinion, he's peaceful, that juries would want to hear about maybe specific instances of conduct that prove that. Maybe talk about a circumstance or an example which, in the minds of most people, might lead them to conclude that the individual is peaceful. Well, the rules don't allow for that. We want to avoid specific instances of conduct, so as a general rule, they're not admissible. However, the judge has within his discretion the permission to allow inquiry into specific instances of conduct on cross-examination, or to allow for inquiry with regard to specific instances of conduct if those specific instances of conduct are probative of truthfulness. Yeah, I know it sounds confusing, so let me explain. Let's go back to our example with Jack, who's charged with armed robbery. And Jack offers Bob as his character witness, who's going to offer opinion testimony concerning the fact that he believes that Jack is a peaceful person. Well, on cross-examination, the prosecution would be allowed to challenge that opinion testimony by offering specific instances of conduct during cross-examination. I'll give you an example. Bob's on the stand, he's offered his opinion testimony, and the prosecutor on cross could start to question Bob about specific instances of conduct on the part of Jack that might lead a reasonable person to believe that Jack actually doesn't have that peaceful character. So let's say if we have prior assaults or other prior incidents that show that perhaps Jack really isn't a peaceful person, well, inquiry into those specific instances of conduct would be allowed. So let's just sort of summarize here. The general rule, character evidence isn't admissible. We allow in criminal cases the defendant to offer evidence of a pertinent character trait as circumstantial proof of his guilt. If the defendant opens that door, then the prosecution can rebut it. How is it normally done? Well, it's normally done by the defendant offering character witnesses on that pertinent character trait, and they offer what's known as either opinion or reputation testimony. On cross-examination, the prosecution would be allowed to challenge or rebut that by